Welcome, and thank you all for coming this morning. Here with me are my Chief Deputy City Attorney, Ron Flynn, and Deputies Elaine O'Neill, Ann Johnson, and Randy Parent, and Yvonne Murray, who have been working very diligently on our investigation in this case, and I want to thank them for their, for their efforts. Part of my responsibility as City Attorney is to protect San Francisco residents and taxpayers from unfair or unlawful business practices. That's why this morning my office filed a lawsuit against the developer of the Millennium Tower. The reason for our action is simple, and that's because the facts in this case are so clear. But it does not make them any less disturbing. My office's investigation shows that the developer, Mission Street Development, LLC, knew for at least a year before they began selling condominiums that this 58-story residential building was sinking much faster than expected. Yet, they went ahead and sold condominiums for a handsome profit without telling the buyers about the situation, even though they were legally required to disclose it. Buyer beware doesn't cut it here. Someone selling real estate must disclose details about known property conditions. The law is very clear on that. When construction of the tower was completed in February 2008, it had already settled almost 6 inches. 6 inches was the maximum amount the developer's own geotechnical engineer had predicted the building would sink over its lifetime. It had almost reached that point more than a year before the developer began even selling condominiums. By February 2009, just before the condos went on the market, the tower had settled 8.3 inches, more than 2 inches over the maximum amount previously predicted by the developer's own geotechnical engineer. After May 2009, the developer had data showing that the tower's settlement was continuing to increase and that it was settling at different rates in different parts of the property, which could lead to the building tilting. Now, the building has sunk 16 inches, and news reports say it is tilting 2 inches at the base. Before they had sold a single condominium, Mission Street Development, LLC, knew their building had sunk more than it was supposed to during its lifetime, and that it was still sinking. Yet they didn't tell the home buyers, and they're required to do so under the law. It's that simple. Mission Street Development, LLC turned over 1,900 pages of documents, including disclosure information about the property as a result of a subpoena that my office issued in September. These disclosures documents discussed everything from the color and veining of marble to noting that the size and types of plants in the common areas of the building could change. But they left out the most important detail. Nowhere that the city is aware of did Mission Street Development, LLC disclose that the building had settled much more and much faster than it was designed to do. That's not just a bit of information prospective home buyers would like to know. It's information the developer was legally required to provide. And it is at the heart of the case that the homeowners themselves have filed against the Trans-Bay Joint Powers Authority and the City and County of San Francisco. My office is bringing this lawsuit in the form of a cross-complaint against Mission Street Development, LLC. We filed it today in the case where a number of Millennium homeowners have sued the Trans-Bay Joint Powers Authority and its members, including the City and County of San Francisco. As you are all aware, the authority is building a transit center next to the Millennium Tower site. San Francisco is one of the members of the authority, but the authority is a separate legal entity from the city. In our cross-complaint, we're seeking damages from the developer that the court deems appropriate. In 2013, when it closed its new sales, the Millennium Tower brought in what the San Francisco Business Times described as a, quote, massive $750 million in revenue. The average price for a condo at that time was $1.8 million. My office has a duty to protect all the taxpayers of San Francisco. We are not going to sit by and allow a developer or anyone else to enrich themselves at the expense of others by hiding crucial information that they're required by law to disclose. That gave the developer, in this case, an unfair advantage against competitors, and it cheated home buyers out of the information that they needed to make an informed choice. And with that, that summarizes what the action that we've taken this morning, and I'm happy to take any questions that anybody has.
Question is this.
Whoa. Gentlemen first. We're going to go in order.
Do you have the option with this suit for rescinding these sales and having these?
No, do not.
And was there a choice to file a criminal complaint? This sounds like a civil complaint.
This is a civil complaint. I do not have the power under the law to file a criminal action, and this is a civil complaint, and that's what I'm empowered to do under the law, and we're not making any reference to any criminal action here, nor have I made any referral to the district attorney or any other person or entity that would have the ability to make that inquiry. Yeah.
Clarify, you're filing this as a cross complaint?
That's correct.
In the class action that was brought on behalf of homeowners?
The homeowners that sued the Trans Bay Joint Powers Authority and the City and County of San Francisco.
Where will the damages go to if you win?
Well, it depends on what the finding is in this case, because the damages are according to proof, and in the event that there was a finding against the city, this would be a suit for contribution and indemnity against the developer, saying that they are the real party at fault.
Is there any sort of injunctive relief you're seeking?
No.
Or strictly monetary?
No, monetary damages, yeah.
Two questions, one of which has to be, how's this thing gonna perform in a major earthquake? Because that's where life is at stake here. All this other stuff is interesting, and there's monetary damages to stand for that. But is this thing going to do what it's supposed to do in an earthquake?
Well, I think that that's what everybody, that should be the primary concern of everybody, that we're protecting life and safety. And I know that there is a review going on by other city agencies to make sure that that the building is safe. From everything that I have been told, the building is safe and could perform in an earthquake. And that's not the focus of my inquiry at this point. But I'm sure, and I know, that the city and the mayor and the Department of Building Inspection and everybody is focused on ensuring public health and safety.
How could the building department not see this? I mean, we're talking about cross-suing and all of this other stuff, but the city and county of San Francisco had building inspectors that apparently, or should have been looking at this thing every minute. And if anybody dropped the ball as much as these developers, it had to be the city and county of San Francisco's building department.
Well, I would disagree with that. The fact of the matter is that while the Department of Building Inspection was aware about settlement in 2009, DBI did not receive any further information about the continuing settlement and the occurrence of differential settlement until this past July. So that's something that will be discussed in litigation. Next question.
One of the issues that you have already said in some of this litigation is that the homeowners waited too late to even file. They're filing against the city. And you said that they've known about it since 2015, and that they should have filed sooner, and that basically you want the city out of their entire lawsuit based on that claim. And now you are intervening on the lawsuit, saying they should go against the Millennium developers. If they lose their right to sue against the city, which is what you want apparently, and then they go against the developers and the developers don't have any money, they're essentially out of luck. How do you sort of compensate for both? You're claiming that they're wrongly suing the city and that the DBI shouldn't have the responsibility of telling them. And on the other hand, you're saying it's all Millennium's fault, but they may not have the ability to pay.
Well, the fact of the matter is, Jackson, that I think what you're referring to is a lawsuit that was filed against the city and an answer that we filed, that we refiled today. But we've been quite clear all along that the focal point of this needs to be on the responsible party, and that is the developer. Because if you look at the claim that's put forth and the complaint against the city, it's basically for nuisance and inverse condemnation, and a claim that there was a diminution in value because of what has occurred. Well, if there was a diminution in value, it was because there was not adequate disclosure made to the purchasers by the developer at the time the transaction was completed, and that is what caused whatever diminution in value has occurred. So from our perspective, the focal point needs to be on the responsible party here, and that is the developer, who has known about this all along and did not disclose information that they were required to disclose to their purchasers or prospective purchasers. I'm sorry, I'll come back to you. Yeah.
Besides the legalese, do you have some compassion for those people?
Certainly. I do. Absolutely. I think that, you know, this is every homeowner's worst nightmare. I mean, a lot of people go through this. They know what happens, what an investment it is to go and purchase a home or a condominium. Sometimes you have people's entire savings that they put forth to purchase something. So that's why what has occurred here is so egregious, and why California law is so strict and expansive when it comes to what you must disclose to a prospective purchaser. The whole reason for the expansive law in this area is so that people don't get ripped off and that they're protected. And that's what, in our view, what makes this particularly egregious when you look at all the disclosures that have been forth, and you talk about marble veining and everything else, and you don't have the most important thing, which goes to the heart of what one would consider if they were going to make a transaction. So yes, I have tremendous compassion for these folks, and that's why we're stepping in to make sure that the developer, that the city is making sure that the responsible party here is paying for their misdeed. You had a question?
Yes, sir. I wanted to ask, is this purely a failure to disclose?
It is. It is.
And that was my question. Thank you.
Okay, this gentleman here.
What's the most recent packet that you guys reviewed?
I'm sorry?
What is the most recent disclosure packet you reviewed? At what
We received 1,900 pages of documents in response to a subpoena that we issued in September.
I mean, what a transaction, a purchase, and what year?
Oh, okay.
Their failure to disclose.
2011. Yeah. Jackson.
Don't you think that although it is the Millennium's responsibility, aren't you a little embarrassed for the city that they didn't even bother to tell anybody, given that it's the city's job to maintain public safety here? And obviously, if they know Millennium isn't telling owners to step in and actually do the right thing when they won't. I mean, in 2009, the city clearly knows that they exceeded, by all measures, the predicted level of settlement. And then they watch as Millennium fails to disclose. Clearly, the city knows that Millennium's not telling the owners. I mean, that's readily apparent, isn't it? I mean,
No, I don't think
the
so.
city should just sit there and let them commit a crime?
Well, let's be careful with the words we use. The gentleman here asked about criminal activity, and I'm not going to say that anybody's committing a crime because I don't have any evidence of that.
Wasn't this fraud?
Okay, so let me answer your question. DBI, there's no doubt that DBI knew about settlement in 2009, but it wasn't until this past July that DBI had additional information about the continuing settlement and the occurrence of differential settlement. Now, so they didn't have all that information, number one. But number two, to the second part of your question, you have to think about who's the one that's dealing with the purchasers. The city is not in the position of knowing what the developer is disclosing to prospective purchasers or not. We're not in privy to contract. The city doesn't inject itself in every real estate inquiry or transaction that is going on, and we don't know what they're disclosing to prospective purchasers. And it was only as a result of our subpoena that we've received the disclosure packages that went to the purchasers, and we saw what was and was not being disclosed. If we followed your logic, fact of the matter is you would have the city being the insurer on every potential home purchase in San Francisco, stepping in and trying to monitor and injecting itself in every real estate transaction to see if the proper disclosures were made or weren't made. And that is simply...
Unsafe condition that you say that they should have disclosed immediately?
They should have.
So then the city's aware of an unsafe condition and lets the Millennium get away with not telling?
No.
I mean, don't they have an obligation to find out what's going on here and actually step in? I mean, it's like the police saying, well, nobody reported a crime, even though I saw it right in front of me. Nobody reported it, so I don't get to make an arrest.
Well, we didn't realize, or we didn't know, that Millennium wasn't living up to its obligation. And the second that we got the information that we weren't aware that they were living up to their obligation, we have taken steps to address that. So I would say, we operate, laws are on the books, people expect that they're going to live up to those obligations, and we become aware that they're not. We're going to take action, and we're going to be aggressive about it, and that's what we're doing today.
Was code enforcement ever involved in this?
I'm sorry?
Code enforcement?
In my office?
No, no.
Well, I have a code enforcement office, that division, that's why I'm asking you the question.
The reason I'm asking is, once these problems started coming up, didn't somebody from the city go down and take a look and say, hey, this is a real problem, and maybe these things even shouldn't be occupied? Because what you're really, when we start talking about taking half this building down, and we're starting to talk about the fact that this thing may not be seated properly to withstand a big earthquake, which is clearly a threat here, how does the city just walk away from that and say, well, it's just not our problem?
No, well, as DBI has gotten information, Department of Building Inspection, that's what I presume you're asking about. They have gotten involved. They are making sure and working to make sure that the building is safe. And I don't think that anybody is walking away and trying to say it's not anybody's problem. The city is being aggressive in terms of analyzing the public health and safety and in terms of disclosures and making sure that Millennium followed their obligation under the law. That's something that we're here to talk about today. Anybody else? Yeah.
Is there any way that this building could eventually be red tagged, and what's the next step?
I can't speak to that. That's something that the Department of Building Inspection, I'm sure, will be continually evaluating and working with the developer as this progresses, and it's not something I can speak to. Yeah.
Could this become a criminal case? I mean, could Millennium Partners be held to fix the problem? And what is the next step?
Yeah,
Because that building is still
Yeah,
being
I can't speak to any criminal inquiry. That's something for the district attorney or somebody else. That's not, we're unaware of anything at this point, but if we were to become aware of something in the course of our case and litigation that we thought demanded a criminal inquiry, we would make that referral. But I don't have any information about that or any indication of that at this point.
Sorry, are you seeking monetary damages?
Yeah.
Right?
This is about monetary damages, yes,
Did you say
correct.
amount? I didn't hear it.
No, according to proof, as that the court determines and as we go through the case.
Have you ever had a case like this? Is this unprecedented? Have you ever sued a developer or something like this?
Oh, we sue people and entities all the time.
In terms of the magnitude of this?
Well, this is obviously I don't think that, this is obviously a very, very serious case and a big case and a high-profile case. But you know what? I'm loath to say that one case is more important than another when, homeowners feel aggrieved or their safety is threatened in a particular project, even if it's not a high-visibility one. But obviously, this is a very, very major case. It's a big development, and I think this is unprecedented in terms of the attention it's getting here in the city. Yeah.
Why didn't the Department of Building Inspection know about the advance rate of settlement until July 2016? Why, is that really,
I can't tell you at this point.
and are you investigating them? Is that part of your investigation?
Well, we obviously, during the course of this litigation, we'll be looking at everything. Obviously, we're going to have to in terms of handling this case, and we'll get to the bottom of everything. Yeah.
Is part of your objective trying to send a message? You talked about how disclosures are something that are part of every person's experience when they buy a condominium or a house. Is part of your objective to send a message that there should be more scrutiny on disclosures, that you will be scrutinizing disclosures, and that developers be warned?
I wouldn't say that, actually, because I think that here in California, because there are such robust and protective disclosure laws, I think that you'll find that in most instances, in purchases of homes and developments, that there is a lot of disclosure, because buyers are sophisticated and sellers and developers are sophisticated as well, and they know what it is that the law requires. And that's what makes this particularly egregious, is that you have a very, very sophisticated developer. But rest assured that if we become aware that someone is blatantly not living up to their legal responsibility, we are going to investigate and take action where appropriate. But I would not say that this is to send a message, because I think that most sophisticated developers and purchasers are well aware of their legal responsibility and live up to it.
Dennis?
Yeah, Vic.
We've heard about Millennium Partners a lot in the stories we've done. Can you tell us a little more about Mission Street Development, LLC?
No, that is the developer of the, obviously an affiliate who was responsible for the sale of the condos in the beginning of the marketing of them.
So they're, would you call them a subsidiary?
An affiliate. An affiliate.
Of Millennium Partners.
Yes. Take two more questions.
What happens next?
Wait. So, JK hasn't had a chance. Okay.
Why did you choose to do a cross complaint on existing suit rather than something under 17,200 or?
Because we thought this was the best vehicle for the case. And we knew that we had to file an answer. And ordinarily, when in a case like this, if you're going to file an answer and you know that you have a cross claim, you would choose to go this route. Two more questions. I'll get to you, Jackson. One for the one of the.
What's next?
Obviously, in terms of our case, the Millennium will be, or I should say, let me be clear, Mission Street Development will be served and with the complaint, and they'll have an opportunity to respond and file an answer, and we'll see where that goes.
You used particularly egregious. You said they had an obligation to disclose and they shouldn't benefit.
Yep.
And yet you're not thinking this is a crime and you're not making a referral. I'm kind of confused. I mean, if these guys profited millions of dollars, much more than the average crime, for failing to disclose a serious problem with this building and walked away with the money, isn't that theft or fraud? I mean, why isn't this a crime?
You know, when you file a criminal action, I know that makes for a sexy soundbite, but all crimes have specific elements, and as we've reviewed this to date, we are obviously, I'm not a criminal lawyer, but we are reviewing this and we see a violation of law, civil law, and if in the event that we felt that there was elements of a crime that were fulfilled, we would refer it. But we do not see any evidence of criminal activity here. And we filed an action, a civil action. This is in the context of a lawsuit. And I do not throw the word out crimes and criminal activity willy-nilly without having evidence of that. And I don't have any evidence of that. And if I did, I'd make the referral to the appropriate authority for them to make that determination. Okay.
Can you tell
Thank
us how homeowners will actually receive the award that the court might make? How does that mechanism work?
No, that's not what we're going to have to see where this goes. This would be about if there was liability that was found, would there be contribution, or who would be held responsible for payment of damages?
Damages do not go to the homeowner?
We'll have to see where things go in this case. There could be other ways. At this point, it's premature for anybody to talk about that. But if you think about damages, yeah, but I can't talk about, I don't know what a mechanism would be because we're at the early stages of the litigation. Okay, thanks very much.